Go! Alright, hi, and welcome back, Attorney Steve Vonder. Welcome to another exciting video. Vonder and Legal Case Brief. Dude, where's my jet? This is the Pepsi points case. This is going crazy. It's blowing up on Netflix. It's really good. Actually, my dentist pointed it out to me and said, hey, have you heard about the Pepsi case? And I said, no, let me check that out. So it's a 4-part series on Netflix. It's really good. And it talks about the issue of whether an advertisement by Pepsi for a Harrier Jet. You see here, this is not the actual ad. This is my reproduction of a Harrier Jet. And so Pepsi ran this program that said you can get a Harrier Jet and other things. If you can collect 50 points, you can get a leather jacket and a hat and t-shirts, things like that. But as part of their TV ad, at the end of the TV ad, they said, Harrier Jet, 7 million Pepsi points. And it showed a guy, a high school kid getting in the jet, no helmet, nothing like that. And it was meant to be a joke, but some people said, well, really, was it? Why wasn't there a disclaimer? Usually you'll see a disclaimer at the bottom of an advertisement. You can't even read it. It's so small usually. But why wasn't there a disclaimer? So an entrepreneurial-minded person from Washington brought an action right here, as you can see, for specific performance on the advertisement. He went and actually got $700,000 together to buy these Pepsi points, and he had the help of an investor to do that. He bought the Pepsi points. He filled out the form. He sent it into Pepsi. He said, yes, here's 700,000. I want my jet. I got the Pepsi points. And he attached the required points that you needed and the order form and so forth and so on. Pepsi sent him a letter back, said, don't think so, dude. That was a joke. Didn't you get it? So here we have it. They brought a case. Actually, initially, as they reference in the movie, Pepsi went on the offense, okay? And we've talked about this in other videos. Check out my video on declaratory judgment. A person who is presented with a claim against them can go and get on the offensive and seek declaratory judgment. And that's just what Pepsi did in its home court in New York. And then the plaintiff, Leonard, filed his own lawsuit. So it was a little weird. You got Avenatti in there. It's a really interesting, it's really interesting. I would highly recommend that you watch it. So let's take a look. Now, he sought specific performance. I'm going to call this video under my Contracts College playlist, Contracts College, Attorney Steve. And they sought specific performance. Specific performance is when you have a contract and you tell the court, the subject matter is so unique, I want the jet, not the value of the jet. The jet was valued at about $23 million at the time, okay? So where you have unique subject matter, like real estate is generally considered to be unique. If a seller does not want to sell you the house and you have a contract, they can seek specific performance. So this is what Leonard wanted in this case. Let's take a look at the background. This case arises out of a promotional campaign conducted by the defendant, producer and distributor of soft drinks, Pepsi and Diet Pepsi. The promotion, entitled Pepsi Stuff, encouraged consumers to collect Pepsi points from specially marked packages of Pepsi or Diet Pepsi and redeem the points for merchandise, as I mentioned. So this guy went ahead and did it. He's here in Seattle, Washington. And he went ahead and did it, and they didn't deliver. And so he sued. Now, this is part of the opinion. I crammed it down to 20 pages. It's actually about 33 pages, but I'm trying to just hit on the basics for you here, okay? So he said there was an offer for a contract. It was an offer, and he accepted it by tendering the payment of the points. The court said no. They granted summary judgment in favor of Pepsi. They said, no, that's not going to work. And let's go down here. I'm not going to, if you want to pause it and read all this, you can. I'm not going to spend too much time. I want to keep this video short. But anyway, he sued for fraud. The court kicked out the fraud claim, said, well, this is just an advertisement. They're not trying to defraud you of anything. It was not false representations of fact made to induce your reliance and to defraud you. It was an advertisement. The key question is an advertisement an offer? Is an advertisement made in jest? An offer that somebody can reasonably accept. We're in contract law. If you have an offer and acceptance, consideration, you have a contract. You have an enforceable contract, okay? So the question is, if it's under jest, Pepsi alleged this is jest, what would the reasonable ordinary consumer think? So plaintiff here, as I mentioned, I'm not you. If you want to pause and read it, he went through. He got the 700,000. He sent the check. This, that, and the other. I'm not going to read all that. But here we have the letter back to the plaintiff from Pepsi. The BBDO Vice President Raymond E. McGovern Jr. said, "I find it hard to believe that you are of the opinion that the Pepsi stuff commercial really offers a new Harrier Jet." Again, those things are like 26 million. There was also a question, can you legally offer a jet that's a military jet? The plaintiff said, well, if you strip it down and it didn't have the military guns, well, it could be non-military. The use of the jet was clearly a joke that was meant to make the commercial more humorous and entertaining. Well, my position on that is, well, why don't you just put a disclaimer then? Little tiny one, this is a joke, in the tiny little font on the bottom. That would have been really nice. And we would never have been in this situation. So this is what happened. As I mentioned here, there was a declaratory judgment brought by Pepsi. Let's go down here. Now, this is the court's decision. This is in the District Court of New York. This is the district court judge's decision that the advertisement was not an offer. Okay, the general rule for you contracts. And guys, by the way, bar takers, don't be surprised to find this on the bar exam. Bar exam test makers like to do relevant stuff that everybody's talking about, just to see how you would react. So this is really good. The general rule is that an advertisement does not constitute an offer. If it's not an offer, you can't accept it, right? The restatement of contracts, second, explains advertisements of goods by display, sign, handbill, newspaper, radio, or television are not ordinarily intended or understood as offers to sell. The same is true of catalogs, price lists, circulars, even though the terms of suggested bargains may be stated in some level of detail. It is of course possible to make an offerment by an advertisement directed to the general public, but there must ordinarily be some language of commitment or some invitation to take action without further communication. So they're saying that generally an advertisement, you see it in the newspaper, hey, come buy this beautiful Chevy truck for, $20,000. They're saying unless there's specific words of commitment, that may not be an offer, okay? Restatement of contracts, similarly, a leading treatise notes, it is quite possible to make a definite and operative offer to buy or sell goods by an advertisement in a newspaper, by a handbill, a catalog, a circular, or on a placard in a store window. It is not customary to do this, however, and the presumption is the other way. Such advertisements are understood to be mere requests. That's my wife. Hang on, honey. I'm doing a video. Such advertisements are understood to be mere requests to consider and examine and negotiate, and no one can reasonably regard them as otherwise unless the circumstances are exceptional and the words used are very plain and clear. So in other words, if you're going to see an advertisement, it better be super clear how much, where, when, how. When can you collect, this sort of thing, okay? So the court went into some cases and this and that. The exception to the rule, however, is that advertisements do not create any power of acceptance in the potential offeree. So you have Pepsico, the offeror, and Leonard, the offeree. He was the one is where the advertisement is clear, definite, explicit, and leaves nothing open for negotiation. In that circumstance, it constitutes an offer, acceptance of which will complete the contract. Offer, acceptance, consideration, collecting all the points, paying the money, all that. In Lefkowitz, defendant published a newspaper announcement stating, and I believe this one will be in your law books, as I recall, Saturday, 9 a.m. sharp, we got the time. 3 brand new fur coats, we got the quantity. Worth to $100, we got the price. First come, first serve, $1 each. Here, the place, 86, where Miss Lefkowitz, a person saw the advertisement, arrived at the store, dollar in hand. But I guess $1 or $100. In what was informed that the defendant's house rules, the offer was open to ladies, but not gentlemen. The court ruled that because plaintiff had fulfilled all of the terms of the advertisement and the advertisement was specific and left nothing for negotiation, a contract had been formed. So they're saying here in the Pepsi case that it wasn't that specific, okay? This is the holding of the judge. Now, reasonable minds can disagree. Some people can say, well, what do you mean? It said 7 million points, Harrier Jet. What's left to be misconstrued? There was no disclaimer. Anyway, that argument on balance did not succeed. The court finds in sum that the Harrier Jet commercial was merely an advertisement. So they're going to get the presumption that it's not an offer. So they go into this concept of rewards as offer. Now, if you see a sign on the tree and it says, "Help, my cat is lost, $500, please, reward," and you act on that and you find the cat, then typically you would be entitled to the reward. And here the court says, in opposing the present motion, plaintiff Leonard largely relies on a different species of a unilateral offer. I'm not going to go into unilateral and bilateral, involving public offers of a reward for performance of a specified act. Because these cases generally involve public declarations regarding the efficacy or trustworthiness of specific products, one court has aptly characterized these authorities as prove me wrong cases, okay? Then we go into this. This is on, if you're a law student, you have to watch Paper Chase. This is great. Paper Chase is an old movie from, 60s or something. I really love this. I really recommend it to law students. Carlyle versus Carbolic Smoke Ball Company. Okay. And so in there was a case, and you could see here, the specific advertisement in this case was $100 reward will be paid by the Carbolic Smoke Company to any person who contracts the increasing epidemic fluenza, colds, or any disease caused by taking cold after having used the ball, the Carbolic Smoke Ball, 3 times daily for 2 weeks, according to the printed directions supplied with each ball. $1,000 is deposited with the Alliance Bank, Regent Street, showing our sincerity in the matter. During the last epidemic of influenza, many thousand Carbolic smoke balls were sold as preventatives against the disease, and in no ascertained case was the disease contacted by those using the Carbolic smoke ball. So they're saying, buy our smoke ball. If you get the influenza, we got money for you. So obviously we're using that to drive customers, to drive interest. On the faith of the advertisement, Miss Carlyle purchased the smoke ball. She used it as directed, but she contracted the influenza. Lower court held she was entitled to recover the promised reward. Affirming the lower court's decision, Lord Justice Lindley began by noting that the advertisement was an express promise to pay $100 in the event that the customer using the Carbolic smoke ball was stricken with influenza. So there are times, if you're pursuing a reward, that's good. However, the court didn't buy that in this case. In the present case, the Harrier Jet commercial did not direct that anyone who appeared at Pepsi headquarters with 7 million Pepsi points on the 4th of July would receive a Harrier Jet. So the court said no, and you can read it here if you want to read it. There's some other stuff. And then the court went on to an objective reasonable person. You heard that in the movie, but they didn't really go into it on the movie. Well, what would an objective reasonable person have thought? Now, plaintiff Leonard wanted to get in, do discovery, find out what they were trying to do, what Pepsi marketing team, what they were up to, what their strategy was. But the court didn't allow them to do any additional discovery, ruled on summary judgment motion. The court did not allow them to go there. But the court was talking about this. No objective person could reasonably have concluded that the commercial actually offered consumers a Harrier Jet. Okay, 700,000 points, 7 million points. I think they were 10 cents each, so it's $700,000. To buy a Harrier Jet that's worth $23 million, too good to be true. The court must not consider the defendant's subjective intent in making the commercial or plaintiff's subjective view of what the commercial offered, but what an objective, reasonable person would have understood the commercial to convey. So this is what we call the objective theory of contracts. It is clear that an offer was not serious then no offer was made. Okay, so again, it must be an act that leads the offeree, that was Leonard, to conclude, reasonably conclude, that a power to create a contract is conferred by the acceptance. An obvious joke, of course, would not give rise to a contract. On the other hand, if there is an indication that the offer is evidently in jest and that an objective, reasonable person would find that the offer was serious, then there may be a valid offer. So it hinges on this objective, reasonable test. And now I guess I would have to ask, well, what is the objective, reasonable consumer? Is it the kids that drink Pepsi? Is it adults? Is it PhD students who drink Pepsi? What is it? So that was a whole nother thing. And again, plaintiffs insistent that the commercial appears to be serious, requires the court to explain why the commercial is funny. So then the court went on. This case is now in textbooks, as I understand, in law schools everywhere. So the court went into explaining why it was funny. Humor can be dissected like a frog can, but the thing dies in the process. The commercial is the embodiment of what defendant appropriately characterizes as zany humor. So Pepsi goes, hey, zany humor. It's a kid taking the jet to school. It's better than taking the bus. Ha ha ha. Isn't that funny? How could you think that was an offer? So that's where they go with that. The commercial in this case makes the exaggerated claims similar to those of many television advertisements that by consuming the featured clothing, car, beer, potato chips, one will become attractive, stylish, desirable, and admired by all. A reasonable viewer would not understand such advertisements as mere puffery. There's a law school term for you, mere puffery, and not statements of facts. The callow youth featured in the commercial is a highly improbable pilot, one who could barely be trusted with the keys to his parents' car, much less the prize aircraft of the United States Marine Corps. He was flying without a helmet. It sure beats the bus, he said. The notion of traveling to school in a Harrier Jet is an exaggerated adolescent fantasy. In other words, it's not real. How could you buy into this? As if to emphasize the fantastic quality of having a Harrier Jet arrive at school, the jet lands next to a plebeian bike rack. This fantasy is, of course, extremely unrealistic. So you see where the court's going with this. In light of the Harrier Jet's well-documented function in attacking and destroying surface and air targets, armed reconnaissance and air interdiction, and offensive and defensive anti-aircraft warfare, depiction of such a jet as a way to get to school in the morning is clearly not serious. Even if it is, plaintiff contends the jet is capable of being acquired in a form that eliminates its potential for military use. So he goes, well, you could strip it of all the guns and everything. Anyway, so that's it. You can see that here. I'm not going to go into this obvious absurdity of the commercial. So the court wasn't buying this. The court was saying, the court concludes summary judgment is appropriate on the ground that no reasonable, objective person would have understood the commercial to be an offer, okay? There was also a finding about this is goods, a jet is goods versus a service. And so the court also added a little extra beef to the decision, saying that it does not satisfy the statute of frauds. Statute of frauds says certain things over $500 needs to be in writing to be enforceable. And nothing here was in writing, okay? And that was it, basically. The case was over. Judge Kimba Wood, and so that's an interesting case. Went up on appeal, affirmed on appeal. There you have it. The Jetsy points case, everybody. I hope you enjoyed that. Before you invest all your time and money, now this case took years. Before you invest all your time and money pursuing something like this, get a legal opinion. Make sure you know what you're doing. Think about it. Look at the case law. Ask yourself, is this too good to be true? Maybe I should just go get a job or something. Anyway, this is general legal information only, not legal advice. Hope you enjoyed this. Feel free to share this on your social media networks. And hey, how about that thumbs up? Give me that thumbs up. You know you want to. Just do it. All right. Thank you all for watching. AttorneySteve.com. That's AttorneySteve.com. Thank you for watching. Bye now.